This is a fireside chat here with ICLE's chief economist, Brian Albrecht. I'll leave Oliver's introduction to him. So thank you. Take it away, Brian.
Thank you. Thanks to everyone who actually organized this. I get to have my name with ICLE on it, but I didn't actually do anything, so this is the best. Today I'm going to have a wonderful conversation, I'm sure, with Sir Oliver Hart. He's the Louis P. and Linda L. Geiser University professor at Harvard. He's also the 2016 co-recipient of the Nobel Prize for his contributions to contract theory. Contract theory is a pretty basic question now within economics, within law and economics. And I think that this is going to be a helpful conversation because we went with the terms substance over slogans, but another idea we threw out was like back to the basics. The idea that we should really think about basic core economics, law and economics ideas. And I really hope that this conversation does that, and I'm sure it will. I was really excited. I thought we'd have a fire. We don't have a fire. I thought we'd maybe have a blackboard in case we had any disputes. We could go and work out the math, but I guess we're not going to have any math either. So we'll have to stick with words, but hopefully that's helpful. So I want to go back and kind of start the conversation at the basics in Professor Hart's earlier career about the questions he was asking and kind of move to the future or to more recent times and then move into more applied questions. So in your Nobel lecture, you mentioned in 1983, you're sitting around with Sandy Grossman and came to like a core question, which is why would one firm buy another instead of using contracts? Kind of a core example of a question that other people might not think is even relevant. Of course, well, they're different things. Why would you tie them together? But if you are really going to the core, you'd want to understand these things. So before getting to think about how your ideas have evolved, can you set the stage a little bit of where the discussion was at the time in the late 70s, early 80s, and kind of over the next few papers, kind of where you came to for the build versus buy, acquire versus contract type of decisions?
Sure. Well, thank you, Brian. I hope everybody can hear me. Let me start off by saying it's a great pleasure to be here. And to be talking to Brian about these issues. So back in '83, I think we were, Sandy and I were aware that there was a literature on this topic, Coase, Williamson, Klein, Crawford, and Elchin. I don't think we were extremely familiar with the details of that literature, but we knew it was out there. What we also knew was, or felt, and I think correctly, that it wasn't a very formal literature. That's why we started working on it. We thought we might, as a microeconomic theorist, we might have something to contribute. And so we started sort of trying to model things, and we went backwards and forwards on different ideas. And eventually we came up with the idea that yes, it all was driven by the fact that any contract that you write is going to be incomplete. And that wasn't new. But what I think was new was we realized, well, a key question is who gets to decide on the things that the contract doesn't specify, and that led us to this notion of residual control rights and ownership of assets. And we realized you can't, you can't own human assets. Unfortunately, once you could, but even then, but certainly today you can't. And but you can own non-human assets, physical assets, whether it's machines, or inventories or land or that kind of thing, but also, and this is of course increasingly important, non-human but not so physical assets like patents and copyrights and that kind of thing, and IP. So we then started thinking about the optimal allocation of these residual control rights. In other words, residual control rights, residual decision rights, it's the right to decide how some non-human asset should be used in a situation where a prior contract hasn't specified how it should be used. What's the optimal allocation of these rights? And I think one insight was, which hadn't really been talked about much at all in the prior literature, was that if I acquire these rights, sure, I now have more of them, but you have fewer of them. So it's not right to think that it's always good for firm A to merge with firm B, that's going to lead to efficiency gains because firm A now has more of these residual control rights. We have to also look at the situation from the point of view of firm B, the previous managers or owners of firm B who have now lost residual control rights, and that might actually be a negative for them, so that might actually lead to a reduction in efficiency. So, okay, so that's sort of a little summary of what we did initially. I haven't got into what the model, how we modeled it, but that was the overarching
2 players,
idea.
2 actions. We can go through the full set. So we don't need to do too much on the math as much as we like that. But I think there's kind of there's an idea that, there's this incomplete contract, therefore there's a way to kind of change the incompleteness if you acquire a company. Okay, yes, some things aren't specified, but this allows you to specify a few more things. I think there's an inclination, at least that I have, that kind of pushes more towards an efficiency defense of mergers, whether they be horizontal or vertical. But I think if you think of incompleteness more generally, someone who's taking incompleteness seriously versus someone who's not, I'm not so sure it goes that way. In contracts with employees or people you kind of bring on for long-term contracts, they also have lots of incompleteness, and then that generates lots of moral hazard. How do you think about kind of the relationship between that incompleteness and then kind of where we set the bar in terms of efficiency defenses in antitrust?
Well, I think that is very much to the point that because you can only, if the only thing that mattered was non-human assets, then you could sort of see why, if I own a machine, one asset, and there's a highly complementary other asset that you own, that could lead to problems when we write a contract about these assets should be used, but it's going to be incomplete. Then later on, we're going to be arguing about something. It might be much better if I own both assets. And I think that is undoubtedly important. But even if I own all the non-human assets, there's still the human assets, and there's going to be incomplete contracts with them. And that sort of gives you pause because you realize, well, you can't control everything. And so maybe the fundamental question is how do we ensure that all the incomplete contracts, including the ones with employees, that works better? Yeah.
I mean, anyone who's been involved in a large organization understands that, those human assets, those actions within the organization have lots of possible inefficiencies, lots of tensions in the incentives, and not all of a sudden, we've merged, therefore there's no problems, because we see the opposite. We see firms unwinding things that don't work out, and lots of problems with that. I want to...
Yeah, so just the bottom line then is a merger is not going to deal with that problem. With the human capital.
Yeah, and that's increasingly a relevant thing as we talk about acqui-hires, that within antitrust there's a possibility that really what you're after are the workers, and you're going to kind of hide it under the guise of the firm. If we think about labor more generally within antitrust, I think there's a lot of interesting questions about what assets are kind of for sale, what can be contracted on, and the like. More recently, you've been working on stuff related to what you call a new approach to contracts, which I think is my reading, it's not in contradiction with your earlier work, but I think it's a different thing than, apologies to the audience, I assume you haven't read everything that Oliver's written. I haven't either. It's a lot. I didn't go through it, but it's a list. But they might not be as aware of this discussion, which I think it was interesting. I think you lead off with the Dell FedEx example and why that's relevant and what that tells us about contracts.
Well, yes, I think maybe it would be helpful if I explain why I moved away from the other stuff. My guess is most people are not familiar with the more recent work, because most people don't seem to be, sadly. But the earlier work was about hold-up. So the model we wrote down, and I later extended it with John Moore, it was a model in which ex post, yes, you have this incomplete contract, it doesn't specify exactly what has to be done, but you can renegotiate. And because we took the view that whatever event that now occurred, which you didn't anticipate initially, it's observable to both parties that it's happened, and therefore it seemed natural to model the renegotiation as happening under symmetric information. And then, Coasian bargaining or Nash bargaining, or whatever you like, suggests, well, we're going to get an efficient outcome. So that led us to then focus on distortions in ex-ante investments. But, over time, and particularly from having talked to people who are involved in contracts, actually writing them, the hold-up problem, which has played a huge role in the literature, I think it's been much exaggerated, its importance in practice, because hold-up behavior, which is basically where I say, oh, okay, we specified this kind of widget, and you now need a different kind of widget, and we're locked into each other at this point. And so I'm really going to take advantage of you and charge you a huge amount for the change in widget. Okay, this is highly opportunistic behavior. I don't think it's that common. It's not that it can never happen, but I don't think it's that common, because usually these parties are involved in a long-term relationship. And if one party behaves that way, that destroys the relationship, and that's just not good. Because they are locked in. It's hard for them to switch to other parties. So they have to really make their relationship work.
Can I ask one thing on this?
Yeah.
So, one basic write-up of the hold-up problem is you're worried about hold-ups in the future. Therefore, you write a contract today where you'll, do something extreme, kill the person, give them negative infinity, utils, and therefore, in equilibrium, in the actual situation, you never observe a hold-up. That we know it's going to happen. We take actions to prevent it. To what extent?
Well, the question is, what actions do we take? I could try to. Yes.
Yeah. So are you saying holdups don't happen, or we don't see lawyers worried about holdups, even if they never actually happen in practice?
I think what I'm trying to say is I don't think most parties are that opportunistic.
Okay.
It's not that they're not opportunistic.
They're not economists. They're not taking advantage of that.
I
right?
don't think they are in the business of thinking, now is my chance to really take advantage of my counterparty.
Yeah, absolutely.
I mean,
so then
there are certain people who operate that way, and I can think of some prominent people. Politically these days, but and if I was writing a contract with them, I would be worried about this. But I think most business people don't operate that way. And that's one of the reasons that in my more recent work, I focused on less opportunistic behavior, which I call shading. So that's where the problem arises, because we have actually a relational contract, because it's a relationship. But relational contracts can also be problematic because things can happen, unanticipated, quote unquote, things, which lead us to, yes, now we have to adjust to the new event. And we may not agree about how we should adjust. Mm-hmm. And that can lead, apart from the fact that it can take time to renegotiate, it can also lead to a residue of bad feeling because I feel that you didn't, you were not really taking into account my situation, and you can feel the same about me, and so there can be some aggrievement, mm-hmm. and that can lead to less cooperative behavior going forward, which can somewhat destroy the relationship. And so what we should be trying to do is to make sure that that doesn't happen. Mm-hmm. And that's what I've been working with a couple of practitioners on how to do that.
And so that work, I see it as having kind of two aspects. One is the more positive, you're drawing out, these are the things we actually see in contracts. But I also think it has a normative, it has a normative aspect of things you should try to incorporate into contracts to help facilitate that, kind of more tying back to what does the optimal contract look like. What sort of insights have you gotten about what contracts could look like or how we could facilitate this sort of cooperation through this relationship?
Well, I think one of the insights is that the sort of classic approach, which many lawyers adopt, you were mentioning lawyers, I think one of the things they do, yes, maybe they are focused on something like hold up. So what they do with their client is they say, we must include all these clauses which will protect you against the other side doing terrible things to you. And of course that leads to the other side's doing the same thing. You get an incredibly long contract which nobody can understand. This is the, let's call it the classical approach. I think it's not the best approach. Because however much detail you put into the contract, apart from the fact that people don't understand it typically, stuff still happens that the contract does not accommodate, does not anticipate. So you're still going to have the problem of contractual incompleteness. And in some cases, actually having so much in is going to make it more difficult to actually deal with the thing that was left out. The approach that I have been working on together with, so the two practitioners are David Friedlinger, who is a practicing lawyer in Stockholm, and Kate Wojtasek, who's an academic at the University of Tennessee who works on supply management. It's a funny thing. What happened was that they were already doing some of this stuff, and I was already doing theory on, together with John Moore, we had a paper called Contracts as Reference Points, which focused on the idea of aggrievement and shading when people disagree about what the right thing to do is. And I think they realized that I was providing some theoretical foundation for what they were doing in practice, and I realized that, well, what they were doing in practice was interesting to me. So we joined forces. The basic approach that they believe in is that you still need a contract. It's not that you give up on contracts, but you don't have all that detail in it. Instead, what you do is you add the idea of, they call this a formal relational contract. You add sort of relational elements that you agree to from the beginning. And I can talk, there are a bunch of them. I'm not sure we want to go through all of them.
Do you have an example of what the...
Well, let me talk about the ones that... So here are two that I think are particularly interesting. One of them is the parties agree, as part of signing the contract or agreeing to work together, they talk about what they're trying to achieve from this contract. That is, this is actually music to the ears of economists. The idea, well, that there's some surplus here. that we're trying to generate. Otherwise, we wouldn't be in this relationship. And we have a collective interest in maximizing the surplus. And we should talk about that. So we should talk about our vision for this relationship, which I think is not something that people usually do. Another thing which is tremendously important is we agree to some guiding principles that we're going to use throughout the relationship. And there are, is it 6 of them? Okay. There are, the guiding principles are equity, loyalty, reciprocity, autonomy, honesty, and integrity. That's 6. The way I interpret equity and loyalty is that we agree to look at, these are my words, I think, but to look at the situation from the other party's point of view as well as our point of view, and take their interests into account as well as our own as we go forward and unanticipated stuff occurs. There's also an agreement to communicate a lot. So we're going to have open channels of communication. I'm going to know if there's something that concerns me, who to talk to, and vice versa. We agree that if something's coming up that might affect the other party that I know about, I'm going to tell them about it, and all these things. And these principles are not just, they're part of the formal contract, but they're not just then put in a drawer and forgotten about. They are things, it's sort of a living document, so we remind ourselves of them frequently. So this is part of the approach. It sounds maybe fanciful to some economists, but the thing is, it seems to work.
I'll see if my wife wants to write one of these formal relational contracts. I don't think it'll go through.
Yes, they could. I think it could be extended to marriage if you were, you'd be a pioneer.
So I think there's an element of that, that you suggested that's a possible way forward to help facilitate cooperation, but there's also, I think, an element of that in existing contracts that you're trying to draw out. Trying to tie this now to antitrust, which is kind of more, and regulation, antitrust and regulation. Do you think it has any implications? How should we think about like joint venture, strategic alliance? Does it kind of pull out efficiencies? Does it make them a little bit more suspect? How should we consider that for those people who are enforcers, or at least writing on enforcement?
Yes. Well, so far, you might be wondering why I'm here. What's it got to do with this conference? I think it does have something to do with it, because what I've learned from the process of my sort of intellectual evolution on this topic to over 40 years, or a bit more, is that maybe one can achieve more through contracts than I used to think, so that maybe, particularly once you allow for these relational contracts and guiding principles. Notice it's a little different from the repeated game literature. There's a long tradition, of course, of saying, that I may cooperate with you because otherwise, everything will fall apart and so on. The folk theorem and that kind of thing. This is a little different because you're actually designing the relationship. With these guiding principles, we're actually designing the relationship. But anyway, once you look at things this way, then the classic efficiency rationale for vertical integration, say, which Dennis was alluding to, I'm a bit more skeptical about that these days. I think that there can be alternatives to that. A good contract can achieve a lot combined with these relational elements. So the antitrust takeaway for me is that the efficiency defenses, to the extent they are important, people should be required to justify them perhaps more than they have. And there should be more skepticism about whether you really need to integrate. And this would be true also to achieve them. It would also be true of horizontal integration. Are there other ways of doing it? So you mentioned joint ventures. Joint ventures can combined with a relational contract could be very effective. Now, people have pointed out to me when I've said things like this, and maybe you're about to point it out to me, but let me anticipate what you might be saying, which is, well, some of those contractual arrangements could also raise antitrust concerns, and that may be true. But at least if people are doing it contractually, I would have thought, maybe this is naive, but I would have thought that it's more observable to the outsiders, including the antitrust authorities, or it could be made observable. You know, what kind of contract have you written? Is this one that we should be suspicious about, or does it sound like it's just achieving some efficiency gain?
Yeah, that definitely makes sense in the observability, but at the same time, you're pointing out that a lot of the relational aspect isn't about the exact written down words. Or if they took you, let's put a hypothetical, this video blows up on YouTube because of this fascinating conversation. Every lawyer agrees. We start writing in the guiding principles, okay? Isn't the contract telling us less as enforcers than we would have otherwise thought?
I think that's a fair point. Yes.
Yeah, there's a lot. I think one thing I really liked about this work and why I wanted to pull it out is just, again, challenging thinking, going back to the basics, you know, about what is the need for vertical integration or horizontal integration. We agree, especially going back to the last section, platforms kind of change these things. I wanted to ask one more thing about a paper that we both really like by Adelaide, Hortachka, and Severson that kind of challenges the standard way we think about vertical integration within economics, as in you can vertically integrate that allows you access to, you know, easier to sell stuff downstream. You don't have the holdup problem. You don't have to worry about negotiating. It's your firm you're selling to, and they argue that actually what you're doing is buying intangibles and things like that. You don't actually sell to your downstream firm. You continue to sell to the competitor. One, what do you think about that knowledge? How does that change how we think about antitrust? And doesn't that actually make like worries about foreclosure less problematic? If you're still selling to your competitor downstream, should we just kind of, they're looking at all cases, not.
Yeah, yes, my memory of that paper, and I think there was a third author as well.
Adelaide, Hortachka, and Severson.
Oh, you said it?
Yeah.
Okay, I missed the first one.
Mispronounced it, maybe.
Yeah. My memory of that paper is that you weren't even buying the stuff from the person you just vertically integrated with. You continue to buy your own stuff from somebody else.
Very common that you don't use that.
Yeah. Well, that was it's a very striking paper. I don't know what the what's happened after that.
Yeah.
It seemed that should have prompted a huge amount of new empirical work. I'm not sure that it has, but in a way, I find it sort of generally consistent with what I'm saying.
Yeah.
Even though what I said, this stuff came after their paper, but that somehow, contracts can achieve a lot. I do think, though, that the explanation they gave for vertical integration is that, I'm a cement firm or a concrete firm, I can't remember which way. Say I'm concrete and I buy a cement company, or I'm a cement company and I buy a concrete company. It's not in order to get their concrete. It's because I actually know the industry and I think I can run them better, be more efficient. That does seem to be actually an interesting situation where a contractual solution might not work so well. So, if I think your company is not being very well run, I could come to you and I could say, Brian, I think you're useless, and let's write a contract where I will sort of tell you how to do better. And because of perhaps for psychological reasons, you're not going to, you're not going to take to that very well.
Yeah.
If you came to me, this is what I suppose consulting companies also do, but it has to be initiated by you. So in a situation where you don't realize what's wrong, but I think I do, this would also in a way be true of activist investors. Activist investors, maybe the best thing is I need to get control. And so I'm going to acquire the company together with control, and then I'm going to implement the efficiency gain. So I think that's a situation where maybe integration is justified, but it's not for the usual reasons, but it's kind of consistent with their empirical work.
Yeah, that's interesting. It makes me think of tying back to the human versus non-human assets. The knowledge that you have is that not, yes, and sometimes knowledge is transferable, but it's an asset that's not always transferable. I want to use this time to open it up for questions instead of me directing all the questions, and at least someone else is going to be interested in this. So someone will come around and get you a microphone so it's recorded.
Rich Gilbert, UC Berkeley, retired though. So I'm a big fan of your work, Oliver, and thank you for all your many contributions. But when I think about antitrust, I'm kind of disappointed that agency theory generally and contract theory don't play a huge role in antitrust cases or antitrust analysis. Even in vertical, with respect to, say, vertical mergers, if you look at vertical guidelines, they're more about, say, the elimination of double marginalization than they are about all of the many things that contract theory could say about vertical integration. And I'm wondering whether you have a perspective on why that's the case. My own perspective is that when you take a deep dive into this literature, little tweaks make big differences in predictions. And that's troubling. Antitrust doesn't know how to handle that. But I'm curious what your view is.
Yeah. Yes, it's a bit disappointing. But, well, the point, double marginalization is a good example. I suppose for contract theorists, I mean, it's hard to be that sort of concerned about that, because why can't, we're talking about two firms, right? Why can't they use a nonlinear price schedule, something like that? It's very odd that they should be behaving in this inefficient way. Again, the question would be, can't they solve that contractually? Sure. And what's the answer? I don't. You tell me the answer.
Well, maybe it's an empirical question.
Hold on just a moment so people can hear you.
Maybe it's ultimately an empirical issue, but the question is, why isn't vertical merger policy more informed by the fact that there are these alternatives that people can pursue?
Well, you're much closer to it, and so it seems to me you have the answer to that, not me. It's a puzzle to me.
Next question.
Hi, I'm Corinne Wong-Irvin. I'm a partner at a law firm, Jones Day, and I too am a big fan of your work. I guess I'm surprised, though, that you are so optimistic that contracting can solve this. I actually think in the U.S. prior to this administration, we really did think about the difficulties of contract. The moral hazard, all of the different problems. So I'm wondering if you're aware of any empirical work that shows that we can achieve the EDM or other benefits through contracting. Because I thought that at least that some of the preliminary work was that it was, we weren't. It was very difficult.
Well, so I think, I'm not sure this is the answer to your question or what you had in mind, but when I think about what my co-authors on this newer stuff are doing, like Friedlinger, Vitasek, so they actually advise clients. They're not, I think they're brought in when integration is not an issue. So the parties have decided are not going that down that road, but instead they want to have a better contractual relationship. And often the reason they're brought in is that the prior contract didn't work well. So, things have broken down, and now the question, but they're sufficiently locked into each other that they realize it's very inefficient for them to break the relationship and go elsewhere. So they just want to have a better relationship, a better contractual relationship. And what Friedling and Vitasek do is they advise them to try this formal relational contracting approach where they combine a formal contract, but not with as much detail as the classic one through the lawyers, but instead to have the guiding principles and all the other stuff the communication, talking about vision and all that sort of thing. And they've done it in about more than 60 cases, and it's worked very well. So I think that would be what I would point you to. Moral hazard is a problem inside firms as well. I don't think that you vertically integrate to solve a moral hazard problem. That's going to be with you always. There are other ways of dealing with trying to deal with that.
Hi, Oliver. Dan Gilman from ICLE. I'm wondering about horizontal contracting and, specifically the antitrust enforcement agencies in the U.S. withdrew a number of guidelines. They've had maybe a habit of doing this without having replacements on hand, which has concerned people. At the same time, you have horizontal collaborations among competitors from 2000. You have 1996 healthcare statements, and certainly these could be updated. So, in terms, do you have an idea about some clear insights from contract theory for new guidance, or at least new research tasks to sort out prior to the issuance of replacement guidance as they redraft these things?
I feel I'm an amateur in the antitrust area. I did once write a paper with Jean Tirole on vertical foreclosure, but it was a long time ago. And I think the main thing that I can contribute is providing extra reasons to be skeptical about the efficiency gains from integration. Because what I'm saying is, I think there are alternatives. And so I would like to see, I would love to, it's not that I'm convinced that there are never any reasons to integrate, but I just, I don't think it's a slam dunk. Just to mention another piece of work I did, but this time with Bengt Holmström. We have a paper on lateral integration, nothing to do with antitrust, but it was, we were interested in companies like Cisco that purchase, they do a lot of acquisitions, and we focused in one section of the paper on Cisco's acquisition of a company called Stratacom, and we argued that the reason they bought Stratacom was because they wanted to control the path of the internet, or whichever part of it they win. So it was more it was actually to do with platforms. It was to sort of make sure that Stratacom's technology would be well integrated with Cisco's technology. And an open question is whether they actually had tried a contractual solution, and it didn't seem to work. So Cisco purchased Stratacom. They didn't try a formal relational contract, and at the time I wrote the paper with Bengt, I didn't even know about those things. So, but going forward, it might be interesting to know whether they could have done it that way. But the empirical work I would like to see, but it's not really about antitrust. It would be about really trying to nail down when there are efficiency, when you really have to integrate and you can't do it another way. I just don't think we have the answer to that. After, Coase wrote his article in 1937 and actually had the idea about 5 years before. So
maybe by 100
we
years.
do the math,
Yeah,
that's
close to-
90, let's say 92 years, and I still don't think we have the answer.
We have time for one more question from the audience.
And with apologies to all of those who did not get the mic, Oliver, you will be around chatting with folks.
I will be
hope.
around.
Okay, very good.
That.
All right.
Yes, yes.
Thank you, Professor. Right now, one of the cases that we're observing repeatedly in CAGI are the non-compete clauses. We know for a fact the FTCs now have a stronger view trying to avoid that, but we're seeing a lot of partial acquisitions with clauses regarding non-compete. One of them was the case IBM SAP. It was actually reviewed by CAGI, and what we had found out is first of all, CAGI allows them. We allow non-compete clauses as long as you demonstrate they are necessary for the operation. And in a lot of cases, what we're perceiving is then when we call the companies cannot justify. And a lot of times, usually whoever is going to be bought actually is relieved to mitigate the non-compete clause. And that was exactly the case with IBM SAP. I believe that's the first time I'm talking about it. What happened when we called the attorneys from both parties, actually one of the companies have a very different understanding of the clause than the one that was selling. And when we put the case on the table, right now they redraft the contract. So do you have a perception regarding non-compete? Are they harmful clauses? They have some efficiency that you believe they are good? There's something we should look at, or it's something that we still don't know?
Yes. I think a bit about that, but not very deeply. But I'm suspicious. Some of them, you read about them, some of them sound totally ridiculous, because, some low-level job and a hairdresser or something, I don't know, and or someone working at McDonald's can't go and work somewhere else. It sounds, what is the economic rationale for that? I can't see any. I can see some, we know there can be a rationale for higher level people, or if you have to train somebody, there's some reason why you want them not to just quit and use that training elsewhere. We know that, and I'm somewhat sympathetic to attempts to solve that problem. Or, of course, if there are, secrets or knowledge that you've acquired from the company, which the company doesn't want you to share with anybody else. I mean, there are situations where something can be justified, like non-compete. There may be other ways of dealing with it, but non-competes could be one way. And then there are other situations, as I say, where they seem to play no economic role, and I would not enforce them. But I think what you were saying, where you actually have to ask why they're there, and then perhaps you find out there's no very good reason, and the company's willing to give them up. That seems like a reasonable way to go.
Well, thank you so much for this conversation. Turn it over to Ian.
Cool. All right. Let's thank our panelists here.
Okay.